What'd you say?
All right, I feel like we've got a quorum of sorts, if you will. We'll go ahead and get started.
Great. So my name's Ivrea Freed. I'm town council. For those that don't know me, my firm, Aries and Harrington, represents the town of Reading, and we often advise boards and committees on compliance with the open meeting law as well as the public records law. So we thought it'd be a good idea with, the changeover. There's a lot of new volunteers right now. We're very happy about that. We wanted to kind of bring everyone up to speed on the open meeting law. And obviously the public records law is a big issue in all communities right now. So giving an update on that as well. All right. So we're going to start with the open meeting law. The open meeting law applies to all public bodies, even subcommittees. So if your public body decides that you're going to have 3 people break off and do some research and prepare a report and come back and report to the whole body, that subcommittee does need to comply with the open meeting law. And that means posting notices. So if you're on a public body, you create a subcommittee of that public body, you need to follow the open meeting law. All right, so I'm going to give a shout out to Laura, the town clerk. She's going to help everyone make sure that they're complying with the educational requirements. But just so you're aware what they are, you need to receive a copy of the open meeting law regulations and the law itself, as well as the Attorney General's guide. And then if there have been any violations from your specific public body within the last 5 years, you need to have a copy of that decision outlining what the violation was. So within 2 weeks, 14 days of, within 2 weeks or 14 days of being appointed or elected to your public body, you need to sign the certificate. And this is for reappointment and reelection. So for those individuals that are constantly being reappointed, maybe to the CONSCOM, we want to make sure that you're doing that every time you're reappointed. And Laura's great about it, sending out those reminders. So what does it mean that we're subject to the open meeting law? What it really means is that all of your meetings must be posted before you meet. And we'll go into detail right now about what that means. All right, so what is a meeting? A meeting is a deliberation by a quorum of a public body with respect to any matter within the body's jurisdiction, and there are certain express exemptions. We're going to go into detail now about these terms. Okay, so there are a couple exemptions. What is not a meeting? On-site inspections, provided there are no deliberations. So if CONSCOM needs to go out and do a site visit, if CPDC is going out to do a site visit, you don't need to post, but you need to make sure that you're not deliberating about specific matters while you're on that visit. Wait until a posted meeting. You can attend an event like the one we're hosting right now, provided you don't deliberate on matters within your jurisdiction. You can attend another public body's meeting, again, provided you don't deliberate. The only caution I put here is sometimes you don't know if you want to deliberate, and it's not that big of a hurdle to post. So if you are the select board and you know a quorum is going to attend the school committee meeting, in an abundance of caution, we always recommend that you post. But technically, as long as no one says anything and you don't deliberate, a posting is not required. And the last one is town meeting, big exemption. Public bodies can be at town meeting and deliberate. That is not a meeting. Right. So what is a deliberation? A deliberation is an oral or written communication through any medium, including electronic mail, it's a big one, between or among a quorum of a public body on any business within its jurisdiction. We have to be careful. It means email. And this is where I'd say 90% of the violations that we see occur is that a board member inadvertently copies a quorum on their email, and all of a sudden you've violated the open meeting law. So you just want to be really careful when you are talking to members of your public body outside an open meeting. And one thing I'll pause here and also talk about is serial communication. So if there's a quorum of 5 and one person tells someone something, and then that person tells another person, and that person tells another person, all of a sudden 3 people have deliberated on a matter within the board's jurisdiction. So you really want to be cautious. If you've already talked to someone on your board or committee about a specific matter and someone else tries to talk to you about it, we recommend just saying, oh, I'm sorry, I can't talk about this. We want to avoid any attempt at a violation. All right, so what is not a deliberation? A subquorum, if you're not a subcommittee. So if your board is 5, 2 people can go off and talk about whatever they want. That's totally fine. You can also talk about meeting agendas or scheduling, procedural information. You know, who's free on Tuesday at 5 o'clock? But what you don't want to say is, who's free at Tuesday at 5 o'clock? I think we really need to talk about lights on a field. I'm really in support of that. You know, then it's become a violation because you've expressed your opinion about whether or not lights should be on the field. And distributions of reports or documents, so long as no opinion of a member of the body is included. So, for example, if one public body member shares a newspaper article in the Globe about a topic that's going to be under discussion, that may not be a violation because your opinion isn't included in there. But if you tack onto that, oh, I really support this person's view, or I think this is X, Y, and Z is wrong with this article, that's when the violation would occur. All right. And for those that have been public body members from some time now, you may remember that there was a very significant case that came out of Wayland. And in that decision, the Supreme Judicial Court in Massachusetts created what we often consider a workaround from the open meeting law. So in this case, the indicta, which means it's not binding, but it's information that the court provides to the public and we can rely on to some extent because the AG has adopted it. The court said that you can share your opinion to a quorum of the public body, provided when you're sharing that opinion, it gets posted at the town clerk's office and online. So the way we usually see this happening is, let's say CPDC is going to issue a decision. Everyone would send their comments to one person. That person would compile them into a document, and then that document would get posted online contemporaneously with being shared with everyone. And in that way, at least in the Supreme Court's decision, it suggests there is not a violation. But what's really important is you have to make sure you're copying the town clerk so it gets posted online and is available in her office. We urge strong caution in using this. If you are going to use this exemption, you want to understand it fully. So contact our office or your department head. There are a lot of limitations with this, but it does provide some ability to have a bit more efficiency as you're operating within the confines of the open meeting law. All right, so meeting notices and agendas. They have to be posted 48 hours before your meeting, excluding weekends and holidays. And I understand that in Reading, town hall is not open on Friday. Friday still counts for purposes of the open meeting law. So if you're meeting on Monday, you could technically post on Thursday. I know Laura likes to see those agendas ahead of time, but Friday does still count from the open meeting law perspective. The meeting agenda needs to include the location and also how to access the meeting remotely if that's how you're providing access to the public. It needs to reasonably advise the public of the topics that you're considering. And this is one that's often forgotten. If you're only meeting in an executive session, you need to have convene an open session as your first agenda item, and then the following items can be executive session. The public needs to know that they're allowed to come to the meeting, at least to see you go into executive session. So that needs to be reflected on the agenda. And again, the agendas must be posted at town hall and on the website. And Laura does a great job. So make sure you're sending those agendas to her, uploading them, however the process works. But those are where they must be posted. Minutes. So this is the other big requirement for boards and committees. The minutes must have the date, time, place, and members present. It has to identify who's participating remotely. And we'll talk about this a little bit later, but if anyone is participating remotely, all your votes need to be done roll call style. So that also needs to be reflected in your minutes. Your minutes don't have to be a transcript. A lot of people put so much detail in the minutes. That's totally fine, but it's not required. You just need to reasonably advise individuals that are not at the meeting about what happened. And all decisions made and actions taken, including votes, must be reflected. And the big one, which is often missed, I think there's one more, is a list of any documents and other exhibits used at the meeting. This is one we see forgotten a lot of times. So if you guys are reviewing a report that was provided by a consultant, for example, it needs to have at the bottom of your minutes, or either at the bottom or the top of your minutes, documents used, and that consultant report needs to be identified. The report itself doesn't have to be attached to the minutes or stored or filed with the minutes, but it does need to be identified clearly in the minutes. Approval. You have 30 days for 3 meetings, whichever comes later. And so if you are a board or committee that meets frequently, if you're the school committee and you're meeting twice a week because there's a big issue coming up, you have 30 days to approve your minutes. If you are a board or committee that doesn't meet that frequently, maybe a couple times a year, then you really have, your 3 meetings. All right. And then are the minutes public record? The answer to that question is yes. And all documents that are used at the meeting are also public records. There's a limited exception for personnel records. And again, you should talk to HR or our office if you have questions around that. But generally, if you're talking about something and you're using the document in your meeting, you've transformed that into a public record. Executive session minutes have to be approved on the same time frame as open session minutes. You can approve the minutes either in open session or executive session. The caution I give is that if you are reviewing your minutes in open session, it's a document arguably used at the meeting, and therefore that document becomes a public record. So if there's something really sensitive in your executive session minutes, you want to go into executive session to review and approve those minutes. You don't want to do it in open session unless you're confident that there's nothing that still needs secrecy within those minutes. In addition, you need to review your minutes at least every 3 months to determine whether they're right for release. So you can withhold executive session minutes provided the matter is still sensitive. So for example, if you're considering a property acquisition and you're still negotiating, we don't want to release that information because it could harm the negotiating position of the public body. But once the property has been bought by the town, there's no reason to continue to keep those minutes confidential. So you must vote to affirmatively release those minutes. You can also designate someone to do that review, but this review often gets forgotten and we want to make sure we're doing it. And once the minutes are public, once the minutes have been released, they become a public record. The documents used in executive session are not automatically public records. We would refer to the public records law to make that determination. So here's a trap for the unwary. Under the open meeting law, you have 10 calendar days to respond to a request for minutes. Under the public records law, you have 10 business days. So we often see individuals getting requests for their board's minutes. They wait 10 business days and they've violated the open meeting law. So if you get a request for your minutes, you have 10 calendar days to respond. So you can either talk about a matter in open session where the public is present, or you can talk about it in executive session. But there are only 10 reasons why you are permitted to go into executive session. So if you feel like you need to talk about something in private, you should consult with your department head or Fidel or my office so that you feel comfortable you're falling within those 10 exemptions. And the procedures for going into executive session are pretty strict. First, you have to meet an open session, then you make your motion. Your motion needs to say why you're going into executive session and needs to invite anyone who's not a member of your board or committee into executive session. The chair, if required, needs to declare that it's important to just go into executive session for certain specific reasons. We can talk about that later. You need to identify whether you're going to return to open session or whether you're going to adjourn from executive session. And then all votes taken, including the vote to go into executive session and votes within executive session, need to be roll call. So lots of people forget to do the roll call into executive session. You want to make sure you're roll calling into executive session as well. So we're going to fly through some of the purposes that are most commonly used, but there, like I said, there are 10. I think we're only going to cover 4. So the first one is to discuss the reputation, character, physical condition, or mental health, rather than professional competence of an employee, or to discuss discipline or dismissal of, or complaints or charges brought against a public officer, employee, staff member, or individual. We see this one used a lot. Generally, we advise you consult with HR or our office. There are notice requirements as well that you have to notify the individual and let them participate. But this is a big one, especially if you have employees, if your department has employees, there are complaints against those employees. You don't want to talk about it in public. You are given the ability to address that in executive session. And like I said, there's specific notice requirements. All right. To discuss strategy sessions in preparation for negotiations with non-union personnel, or to conduct collective bargaining sessions or contract negotiation with non-union personnel. So purpose 2 is used frequently if you have a union or you're negotiating when you're hiring department heads. And number 3 is another purpose related to collective bargaining. This one covers grievances as well, also deals with litigation. So if you're dealing with any administrative appeals in front of DEP, if there's a wetlands permit that's been appealed, this purpose here gives you the ability to talk about it in executive session. The litigation has to be pending or imminently threatened. You can't just go in because you feel that someone may sue you. If you feel like you need to use this exemption, you really want to be contacting your department head or our office. Purpose 6 deals with purchase or leasing of land. So we use this one a lot. It's important that the chair declares that discussing the matter in executive session would harm their negotiating position, and you need to identify the property. And purpose 8 is another one that we use frequently. It deals with hiring. So this one says to consider or interview applicants for employment or appointment by a preliminary screening committee if the chair declares that an open meeting will have a detrimental effect. What's really important with this one is that if you notice, it says preliminary screening committee. So this is just the first step. Let's say you have a whole batch of applicants and you want to narrow it down. You are permitted to go into executive session to narrow it down. Once you've identified your top 2 or 3 applicants, at that point, all of the discussions need to be an open session. In addition, it needs to be a preliminary screening committee, which the Attorney General has deemed to be less than a quorum of your public body. So if the school committee is hiring someone or thinking about appointing someone, they can't all be members of the screening committee. They'll have to choose just a few to be members of that screening committee. All right, so everyone knows that COVID impacted our public meetings. Recently, the governor signed an extension to our remote access policies until March 31 of 2025. So the rules now is that the public body members may participate remotely without a quorum physically present. Under the standard remote access provisions, a quorum and the chair would need to be physically present in the meeting. But now the entire board can be remote or a portion. And public access can be provided in person, hybrid, or remote only. And so if you are going to participate remotely or have anyone participating remotely, you need to announce the names of all the members participating. And so there's been a few Attorney General decisions finding violations where individuals participating remotely were not identified. You can't tell when you're looking at a screen and there's 20 people on the screen who are public body members and who's not. So the first thing that we always advise is that the chair say, you know, so-and-so, so-and-so, and so-and-so on the screen, and these 4 people are present here. You just want to identify everyone that is a public body member so that the public knows who they should be looking at. And then all votes need to be roll call if anyone is participating remotely. In terms of access to the public, it needs to be immediate. So live stream, telephone, local access television, those are all sufficient. Recording and then posting it later online does not meet the requirements. And appeals. So appeals go to the Attorney General's office first. Generally, there is a provision for Superior Court, but 99% go to the Attorney General's office. Boards have 14 business days to respond to an appeal and address it. What I always advise is, if you think you made a mistake, if you think you did something wrong, reach out. We can fix it. We can fix it. Being proactive is the best way to approach this. So if you think something went wrong, let us know. We'll help you out. All right. So I think I'll pause here and take questions. I know that was super quick. Take some questions on the open meeting law. Generally, when I do this, it's I like to take questions throughout, but because we're split, I thought it'd be easier if I just went through the slides first and then we can open it up. I do just, before we take questions, I just want to say because we are being filmed, you know, if you have a sensitive question, maybe hold it until after. And if I don't know if a quorum is present, so just make sure if you are talking about a matter that's in front of your public body, talk about it in hypotheticals or in general. Don't talk about the specifics of the actual matter.
And to anyone that is on Zoom, if you don't mind raising your hand first, just so it's easy to see who would like to ask a question. We'll start with the room first.
Yeah.
Can you go back just a couple of slides to under COVID times, what counts right there? What's accessible to the public? So having a meeting in a public space and publicly posting it is not enough. You also have to do live streaming or a telephone or local access television.
No, so your option is that you can have in-person only. That is always available to you. That's what the open meeting law requires, is that there's physical access to the meeting. During COVID, that requirement was suspended. And instead of having physical access, you could have remote access. If you choose to have remote access, it needs to be immediate. So live streaming, telephone, local access television, that type of immediate viewing platform is what has been deemed to be sufficient. If you're holding, the only caveat is, if you're holding a public hearing, if you're the Board of Health and you have a public hearing for CPDC and you're having a public hearing, then you need to have a way that members from the public can participate in the meeting. And so generally Zoom or telephone is the best option for that, because you can have them participate. But if you're just having a general meeting, you don't need to have public participation. That is at the discretion of the chair.
I get that question a lot. Thank you.
Yeah.
Martha Moore, Chair of the Conservation Commission. For the purpose of writing up our minutes, once we've done a roll call vote, if it's unanimous, can we just write 500 for our minutes and we don't have to name every single person? And if it's not unanimous, do we need to write who was the dissenting vote?
Right. So if it's unanimous, it should say unanimous via roll call. The words roll call should appear if you're not going to list everyone by name and how they voted. If it's dissenting, yes, I would advise that the individual who votes a particular way be identified.
Does open meeting law apply to social media posts and comments on postings?
Yeah, great question. The answer is yes. So remember, deliberation can occur through any platform or media. So what does that look like, right? So we've seen Attorney General decisions where a public body member has posted their views on their personal page and no one has responded. They're just putting it out there for the public. The AG will say, even if that crosses the eyes of a quorum of their public body, that is not a deliberation. There needs to be some level of active engagement. So for example, if the town has a Facebook page and there's a post that goes up about installation of new crosswalks and a CPDC member chimes in, and then another CPDC member responds to what that member posted, and then there's an engagement, the AG will find a violation in that case. So you really do need to be cautious as you're using social media. How are you directing your communication?
Just to piggyback off that. What if you just like a post, or you know how Facebook has the different emojis you can like,
Yeah.
love, care.
Yeah.
If you just like a post that voice comes across.
Yeah, so if a member of a public body says, I really support the installation of crosswalks, and then another member of that public body likes it, I would be concerned about that because it's two members expressing their view that the crosswalk should be installed. So I think, yes, maybe there's more room for interpretation on what a like means, but in my view, that would be an area of concern.
Any other questions in the room?
Just to build up on that, so if you have 5 members
Yeah.
and you have 2 members discussing, that shouldn't be a violation.
It shouldn't be a violation, except if they know that there's a quorum watching that communication. And so it gets really tricky, right? And so that's why our advice typically is hold all of your communications related to matters that are in front of your board to a posted meeting. You're not stripped of your First Amendment rights when you become a volunteer for a town. So you're able to write newspaper op-eds, you're able to post things, but we do want to be cautious when we're engaging each other in a very open platform like social media, because even if there's an argument that you're not violating the open meeting law, the perception might be that you are. And that's when we see open meeting law complaints being filed, and it wastes your time, wastes town council's time, so if you could avoid doing that, that's the best path forward.
Anyone else in the room?
Completely different.
Yeah.
Can you do commercial business or professional business with a fellow board member without being a conflict?
So
Nothing to do with the agenda.
yeah, so that would the question that's asked pertains to the state ethics law, and the answer is very complex. So maybe we can connect after. It's yes, but is the short answer.
It depends.
Yeah.
Came up recently,
Yeah.
Anyone else in the room? All right, Dr. Lopez?
Yeah, I wonder if you can talk a little bit about agendas in public meetings. At what point does having an agenda go, or discussing the topic, go beyond what the agenda was posted? So for example, if during the public comment section, there's a comment, and then there's a discussion of that comment by the committee, at what point does that become an agenda item that wasn't posted? Or if you have a generic agenda item, like, monthly report, and there's, as part of that generic item, there's a substantial conversation about a particular issue, does that violate, not posting that agenda item in advance? Where are the borders around this?
For sure. So you sort of asked 2 questions. So I'll take the first one. If during public comment, someone comes forward, raises an issue, and the board wants to discuss or respond to that individual. So under the open meeting law, the chair must include on the agenda all topics that they reasonably anticipate being discussed during the meeting. So if the chair cannot reasonably anticipate that the public comment is going to come forward and that matter is going to be brought forth. Legally, you can discuss it. Best practice is to tell the person, thank you for raising this. We will add it to a future agenda and then discuss it in full at that future meeting. However, if the chair does believe it's essential to discuss the topic now, let's say it's time sensitive, and they really could not anticipate it being on the agenda, it would be a permissible discussion to have. So that answers, does that answer your first question?
Yes, it does. Yep.
Okay, so best practice is to hold off, but there is leeway to discuss it if you feel like it's absolutely necessary. In terms of what if there is a topic on your agenda, what are the bounds around it? So the agenda item needs to reasonably advise the public of what is going to be discussed. I'm not a fan of agenda items like update. I think that those are overly vague and can be questioned. So I would rather have more specifics, liaison report updates, regarding school committee. And then maybe there's a prom, Killam School is identified. So the more detail you can provide in your agenda, the better. There is a line of cases from the Attorney General that discuss topics that organically develop. So if your agenda item is the Killam School update on fields, and then from that, what organically develops is a discussion about funding for those fields, let's say. That is permitted to be discussed. Now, we're talking a lot about gray areas and it's a lot of fact specifics. So what I say is, if you don't believe someone knows what someone would look at the agenda and reasonably anticipate what you're talking about being discussed at that meeting, I would hold off if possible for a future agenda.
Okay,
Does
thank
that
you.
answer your question, or do you want more?
Yes.
Okay.
No, that's good. That's
Yeah.
helpful.
Yeah, so some people put new business as an agenda item. The Attorney General has also found that new business does not provide the requisite level of information. So we would advise that no one include new business as an agenda item and put exactly what the new business is, outline it. It's okay to say future agenda topics, and then boards and committees can say, I would like this topic added to a future agenda, but don't go into detail about it. Just articulate that you want that agenda item to be included. I think the select board has that as one of their agenda items, but they're very cautious that they don't discuss it. They just articulate that this is something they want to see on a future agenda.
Thank you. Anyone else online that has a question? I see no hands raised. Anyone else in the room that has a question?
Great. Yeah, and so if later tonight, something comes up, reach out to your department head, reach out to Laura. If they can't answer it, they'll reach out to me. I'm happy to provide more detail. Open meeting law is really fact specific. I can't stress that enough. And so it's hard to answer specific questions without knowing all of the background. All right, so now we're going to turn to the public records law. And this is going to be geared more towards individuals that are dealing daily with responding to public records law questions. So for those that are online or in the room and are public body members, I think what I'll do is I'll say these are the main takeaways. The first is that you should think of everything that you have created in your capacity as a public body member to be a public record. There may be an exemption that prevents it from being disclosed, but you want to view everything you're writing or documenting as potentially a public record. The second is that you should make sure you are using your town given email address as much as possible. And if you were not given a town email address, I would advise creating a Gmail address, Ivrea@Conscom, like you want something that segregates your work-related emails from your personal emails as much as possible. And the reason for that is if you have to do a search, it becomes incredibly complicated to search through your personal emails. We like to see them all in one place. And finally, the last is that there are a lot of retention requirements that apply to public records. So if you weren't using your town given email address for whatever reason, you're using a personal email address, before you leave service, you want to make sure you're communicating with IT to see if we can get those emails from you. Perfect. Okay, so what records are subject to the public records law? And like I said, it applies to all documents made or received by a public officer or employee, regardless of format. So what I like to divide it up into two sections. Government property. If you're sending something from your town email address, text messages from a town provided phone or a town Twitter or Facebook, it's automatically considered a public record. So if you are sending an email from your town email address to your wife or your husband, your spouse about picking up your kid, that's a public record. It may be able to be withheld, but you've created a public record. You just want to be cautious. And if you're sending something from private property, but it's sent as a municipal official, those are also public records. So from your personal email, you're texting on your phone, if you're using your social media account, you could be creating a public record, provided it deals with municipal business. And like I said, there is a presumption that the record is public. And I just want to reiterate this one more time. You are creating a record, it is likely public. So there are numerous exemptions. I'm not going to go through all of them. These are the most common. So exemption A deals with it's a statutory exemption. So for example, anything that's protected under Corey, anything that's protected under student privacy laws. If there's another statute out there that deals with privacy for a record, we can withhold it under exemption A. Exemption C deals with privacy. If there's a matter that is highly sensitive, you're emailing about your divorce to social services, something like that could be withheld under exemption C. Deliberative process. If a board is considering whether to adopt a policy and you're going back and forth about specific issues, as long as you haven't finalized the deliberative process and voted on the particular policy, then those emails may be able to be withheld. Exemption N deals with security. There's going to be a road rage, for example. Where are we going to have police officers? Where are we going to have cameras? That type of stuff can be withheld under exemption N. And one that appointed officials really like is that appointed officials' home addresses and telephone numbers are protected. Elected officials are not, so that information is public. But for appointed officials, you get the benefit of that privacy. And then attorney-client communications. So what I do want to point out is every exemption that's on this list, except for exemption A, is discretionary. The town, in its discretion, can decide to release appointed officials' home addresses and telephone numbers if they so choose. Anything that falls under exemption A, the town cannot elect to disclose. So we can't violate the Corey statute. We can't violate student privacy laws. But everything else, it's within your discretion to withhold. The town, and Reading in particular, generally elects to exert these exemptions and withhold the records, but it doesn't have to. And like I said, there's a lot of exemptions. If you have concern that a record shouldn't be released, ask Laura. She knows this really well. Ask your department head. We'll get you the answer. So you think you have a request. What do you do now? So there's two ways a request can come in. It can come in a very formal manner. I'm requesting pursuant to the public records law, all emails sent by the town manager. You can also get an informal request. Someone goes over to the building department and says, I want to see a file. That is technically a public records request. What's most important is when you do get a request, especially if you're an elected or appointed public body member, is to copy your department head and send the request to Laura. Laura maintains a database of all public records requests, and she helps to make sure we're responding appropriately and within the time limits that the statute outlines. So I always like to say, the first thing you do when you think you have a request, email your department head and Laura. contact the RAF. Yeah. So you have 10 business days to respond, and there's a couple different ways that you can respond. You can provide the records right away. You can say there are no responsive records. You can tell them why you're not giving them the records. You can seek additional time, up to 25 business days. You can ask them to modify the request, to clarify the request, or you can give them a fee estimate. So there's a lot of different ways that you can respond to a request. If you are doing anything other than telling them we don't have the records or here are the records, you need to give them their rights to appeal. So your response to them needs to say, you know, we'd like a modification. Also, if you want to appeal to the supervisor of public records, you can do so. So you really want to make sure that you're working with Laura or your department head to properly craft a response if you're doing anything other than producing the records or saying we don't have records. All right, so when there are no responsive records, there are two ways to deal with that. One is you can say no responsive records, or you can say no responsive records plus here's a brief explanation as to why, or here's a record that may be similar. This is really what you're looking for. And it's within the discretion of the individual in control of the records to make that decision. But from a legal perspective, I just caution the second option because sometimes it can lead to more and more requests. So you want to sort of think about what is the best approach given the situation. And you can be as literal as possible, you know, in responding. You don't have to help them. You can, certainly, but you're not legally obligated to do so. That's a policy decision for you to make. All right, so if you are going to withhold a record, you really should be speaking with Laura, but the letter must include a description of the document withheld, the exemption, how the exemption applies. If it's attorney-client materials, we need a privilege log, and again, the right to appeal. So we see a lot of missteps here. Someone just says, oh, you know, this record deals with a sensitive matter, therefore we're not giving it to you. And the supervisor of public records will find that to be insufficient. You need to describe the record a little bit. You need to explain that this is exemption C. We're dealing with a highly sensitive privacy issue. You want to explain why the letter to some extent it has privacy concerns. For example, the requested record deals with a family matter, and then obviously outline the right to appeal. So we need to make sure we're going through the requisite level of detail if we are withholding a requested record. If the request is really large, you can get 25 additional business days. I'm sorry, you can get the time period extended to 25 business days from the date of receipt. So if you feel like you need that additional time, we can help you out there as well. Great. So modification or clarification is generally the most used response back. We see requesters that don't really know how to formulate a request. So they'll say something like, I want all records pertaining to the Cook Street development. And through the request, you know, if you do a modification back and forth and engage the requester, you may learn that they actually only want emails that the CPDC chair sent between a very limited time period. And so it helps out everyone if you get a very broad request to make sure you narrow down and drill down into what they're actually looking for to the extent possible. So we often use this when we see, as a first step, when we see big, broad requests. And it can be helpful to tell them, you know, if you want everything related to Cook Street, it might be over $100,000 because it goes back decades. And so that could, you know, remind them, okay, really, what do I want here? All right, so we are able to collect fees. We can recover our time, but there are a lot of limitations on what that looks like. So you can always collect fees for the time needed to search for and pull records from files. So let's say someone comes to the building department and says, I want building permits for this specific property, and you have to go into the archives and you spend 3 hours pulling those out. You can charge fees for that automatically. You don't need approval from anyone to do so. You do need to give them a fee estimate ahead of time, and they can be required to pay before you do the search. But you don't need approval to do that. You also can charge for redactions that are required by law or attorney-client privilege automatically without supervisor or public records approval. So if you are within the police department and you have a whole bunch of Corey protected records that you need to review and redact, you can charge for your time. It may have only taken you 10 minutes to find the records, but it might take you 3 hours to review them. So you can recover those. If the redactions are not covered by exemption A, meaning it's a discretionary redaction, then you need to first get approval of the supervisor of public records to charge fees. And so this is really common. So we see emails being requested between select board members, for example. A lot of those emails may have very sensitive information in them, but none of them are protected by exemption A. They may be a discretionary personnel exemption, you know, it could be HR materials going back and forth. Before we can assess fees for reviewing those emails and redacting those emails, we need approval from the supervisor of public records. And so how do we calculate the fees? So Reading has more than 20,000 residents, and so you are not able to charge for the first 2 hours. So when you're looking at whether we should do a fee estimate or not, if it's going to be 2.5 hours, the amount of time that goes into creating the fee estimate for 0.5 hours may not be worth it. You might just want to give it all for free. So it's a balancing test for the individual that's in charge of the records to do, but the first 2 hours are always free. You can charge $25 or the lowest paid, the hourly rate of the lowest paid person capable of performing the task, whichever is lower. And so, for example, if the building inspector needs to go and pull the files, is it his hourly rate is more than $25 an hour, then you can only charge $25 if he's the lowest paid person capable of doing it. If someone else in his office could do it that makes less than $25 an hour, even if he's the one physically pulling it, you can only charge that other person's rate. You get 0.5 or 5 cents per page for copies and the actual cost of production for large print, USB mailing, those sorts of things. And we advise that you don't start your production until the payment is received. So you can, like we said, you can always petition the supervisor to charge additional fees above this, but this is the standard statutory rates that you can charge. Like I said, you can petition the supervisor. You can charge for the time to redact. So, you know, we have to go through hundreds of select board emails. Lots of them deal with deliberative process or personnel. We can petition to get the ability to charge for that fee. You can charge over $25 per hour. If I'm going to have to review some of the records, we might want to recover my time or a portion of what I charge. You can also get relief from responding. These are granted very infrequently, but if you have a harassing requester who's filing repeat public records requests, you know, contact your department head and Laura. We may be able to help there. And you can always get additional time as well. The fee petition has to be sent within 10 business days. This is really important. And so you want to reach out to your department head or Laura if you're going to petition, but you only have 10 business days to file that petition. Okay, and then this is sort of a best practice slide. When the request comes in, you want to document the due date, inform Laura, inform your department head that you got the request. And then I like to break it up into 3 steps. Am I going to produce the records or say no records? Am I going to ask for a modification, or am I going to do a fee estimate if it's minor? That's sort of step 1. If you've done a modification, then the next step would be to either say, oh, after you've modified, there's no responsive records, or here they are, or you then have to look at the fee petition or fee estimate. But I really do want to stress the modification. I feel like a lot of people come to me, they say, oh my God, I got this huge request, I'm so overwhelmed. And I say, oh, don't start it. Like, let's try to see if we can get them to modify it. So, you know, always having that engagement with the requester as the first step, I find to be a very helpful step in the process. All right, some things to note. If the record is available electronically, you must provide it in an electronic version unless they've requested for it to be in hard copy. This is the one where we see a lot of slip ups. It needs to be searchable, a searchable PDF. So if you have a searchable PDF and a non-searchable PDF, you got to send them the searchable PDF version. And then I always like to say, should this be online? You know, if you're getting requests for a specific permit that the CONSCOM issued, put it online. Then you can just direct all of the requesters to the website. You don't have to then copy it and paste it into the email every single time you get it. So if you're finding that a document is being requested frequently, we want to make sure it goes online. Under the public records law itself, we are required to post some documents online if feasible. There hasn't been a lot of explanation about what those documents are, but generally we interpret them to be minutes, agendas, procurement contracts, and significant permits in town. So those are what we like to see always posted online. But like I said, if there's a big project coming up, I know Reading does a great job of this, create a page, post the records. It avoids getting the requests. Appeals go to the supervisor of public records or Superior Court. And if you do get an appeal, don't worry, reach out to Laura. We can help you. Generally, the process is that you do get another opportunity to tell the requester why a record should not be withheld. The supervisor won't automatically order release. Typically, they say, can you explain it again, why you feel this record should be withheld? If you fail to respond within 10 business days, they're going to order you to move forward and deal with the request. But if it's an appeal due to what the requester believes is improper withholding, you typically get a second bite at the apple. We do want to be cautious because one of the things that the new, I guess not that new, 4 years old now, public records law gave to requesters is the right to collect attorney's fees and to get compensated if they have to go to court to get the records from the community. So we do want to be cautious that these are significant obligations and we need to follow through. Great. One thing we get a lot is, can I ask who the requester is? And the answer is no, except if you want to withhold the record for security reasons, but you don't have the right to know who a requester is. And retention. So this is a whole nother beast, but there is something called the Municipal Records Retention Manual, and it outlines how long communities must hold on to certain records. It is very complex, makes very little sense, and is not intuitive and should be thrown away, but it is what we are left with. And so unfortunately, the easiest path forward is not to throw anything away. So we really want to hold on to every record. If you do want to dispose of something, talk to Laura. She can help you work through this. But aside from a scheduling email, you really want to make sure you're holding on to everything unless you have approval from your department head to destroy the record. Any questions?
Should you always put modifications in writing when you're dealing with the requester, or is it okay to just talk to them by phone and ask?
Yeah, so I think it depends on your relationship with the requester. If you have a friendly relationship with the requester, that's fine to give them a call, ask, but then what you want to do is follow up with an email, just summarizing our call, this is the new request, and then put that in writing. So one thing to note is public records requests, like I said, can be made formally or informally. A requester can't appeal verbal requests. They can only appeal requests that are made in writing. But in your case, Matt, I would say if you have a good rapport with them, it's okay to do it as long as you follow up with an email.
That's what I usually do.
Mm-hmm.
So I mean, we get it all the time with the property jackets and plot plans and stuff like that. I mean, is it something that, say a contractor or homeowner is coming in saying, hey, is there a plot plan available for this property? I mean, is it a process to send them down to the clerk's office, or is that something that should they be going through the record request process?
Yeah. So I defer a little bit to Laura on that. If you feel like you can just grab the file and hand it to them, that's fine. If you feel like, oh, I actually need to review this, I'm not sure if everything is public, that's when I would just at least let Laura know, hey, I got this request. I'm going to take some time to look through it. But I guess, Laura, would you like him to?
So if you're positive that the record is a public record, then go ahead and issue the record. Just notify me that you've done that and we gave it to you so I can track it.
Okay. Yeah, and I mean, we don't want to get in the way of efficient government, you know, so if you can just give them the record.
Yeah, that's the biggest thing I usually see, you know, a plot plan or whatnot. And then in terms of the fees, I mean, who would be requesting? Obviously not on, I mean, the first 2 hours, but sometimes they're coming in with developments saying, I want every permit pulled for 300 houses.
Yeah.
I mean, is the clerk requesting the fee? Are we requesting the fee? Once it's set up, obviously.
Yeah.
Whose, I guess, jurisdiction would that be?
Yeah, so again, I'm going to defer to Laura. So under the law, the RAO is supposed to be sending those, but but they can authorize other individuals to send them. So I've seen in some communities where they have given that authorization. I don't know, Laura, how would you like it
Yeah,
handled?
we have several other RAOs that work with the town. For your group, it generally goes through me.
Okay.
As far as the fees, but we can talk about that.
Yeah, yeah, absolutely.
If
Yeah.
that's something you
Fine.
want to do, then
Yeah, we can meet up and, I mean, like the smallest stuff, I don't really see a problem with, but it's just when you get into the, I mean, you see all the requests, like some of the requests that come in, it's like, it's weeks sometimes of time that is taken to get them. And then, you know, if town council has to get involved with legal terminations or something, I just feel that should be some kind of recoups for some of that.
Absolutely. I would say if you're spending more than 2 hours pulling records, you should be recovering your fees. So you should reach out to Laura or at least have that conversation with Laura, you know,
Yep.
what's standard here? What do we normally do? And how would you recommend I handle it? But if you anticipate more than 2 hours, I would reach out to Laura.
That's perfect.
so the easiest, just real quick, the easiest way to notify me with the records request is if you're emailing out the request, just copy me in.
Okay,
And then I can just track it that way.
perfect.
Anyone else in the room with questions? Anyone online with questions? I don't see any hands raised. We're at 1 hour.
Yeah. It's great. I mean, sometimes it just takes an hour, but I just like to leave room for questions. And I'm happy to answer anything offline too. And there is a process to contact town council. So if you don't have authorization, just make sure you're going through your department head.
All right, thank you.
Thank you.
Thank you, Rebecca.
Yeah.